This is 1320 WILS. Look, he was a fighter in life. Muhammad Ali dying on Friday, age 74. But now the real battle begins over his $50 million fortune. A man who has had 4 wives and 9 children. Well, it's all just begun. Let's talk to Jasmin Dodson, a legal expert, DodsonLegal.com, an attorney who's dealt with all kinds of estate planning issues. Jasmin, thank you for joining us.
Thank you for having me on the show again.
Yeah, so this is his 4th wife, Lonnie. She's going to be the executor. So when you're the executor, how much power do you have?
As an executor, it depends on the will. The will detail the specific powers that an executor would have, and if it doesn't, then basically your job is to be a fiduciary of the estate. So being the executor of an estate does not necessarily mean that you are entitled to any benefits over and above anyone else. It just means that you're the one that's responsible for dishing out the funds. Now,
we know that he had Parkinson's, and there are family members that say that this Lonnie, his 4th wife, was keeping family members away from him, and they feel that they may have been left out of the will. How much legal action can they take if they feel that somehow Lonnie was manipulating him?
Generally, what happens if someone disagrees with a will as it's written, then they'll file what's called a will contest. And in a will contest, you can allege all different types of actions, such as undue influence, coercion, that lack of capacity, these types of things. But then the burden is on the movements to prove that these actually existed during the time the will was drafted.
So if you tell a judge, hey, you know, this wife of his wasn't letting us see him for years, would that help your case somehow, or is that not enough?
Possibly. I think it depends on the facts. In most situations, the judge might ask, well, what efforts did you make to try to see your father? Did you file charges of elderly abuse? What did you do in furtherance of it, or did you just sit on your hands and wait until the will was out, realize you didn't get anything, so now you want to complain?
9 children, obviously, 3 exes or so. So if it turns out that like 90% of his money is left to the 4th wife and her children, would that be questionable in your mind?
It could be, but you kind of have to look at the facts. A lot of times, in my experience, because I also do draft wills, it is in the testator, who is the person who's drafting the will. It's based on their circumstances and what's going on in their lives. There are several different reasons as to why individuals might be omitted from wills, and they generally go with who the person is that's taking care of them at the time. We never know what happens between the relationships of the people and why they decide to give certain things to other individuals.
Is that the tendency, though, that if you have multiple wives, it's the last wife that tends to get the fortune?
Not necessarily. You'd be surprised. There's been situations where current spouses may be omitted from a will, and previous spouses may hold title some other way.
So do you, I mean, is there any question in your mind that he's got a very specific and laid out will?
You know, I haven't had a chance to examine the will. I'd be really excited to see it if they do release it. I'd like to read through the copy and find out what he left and how he left it. And what the will actually looks like.
Yeah, if you have 9 children, right, and you don't leave a will, what kind of mess would that be?
Well, it depends state by state. Each state has different laws and regulations as to how property and assets are divided, depending on whether or not you're married and have children, you're unmarried and have children, whether you're married, have no children. Sometimes it could end up going to your parents. Sometimes it could end up going to your siblings. It just depends on the individual's estate and how many heirs they have left.
Really? So
and an heir could be anybody from a child to a sibling.
Children don't get priority over siblings, you're saying?
Children do. Well, in the state of Texas, children do. However, if they are not your natural children and you didn't adopt them, then they don't get priority. But if they are your biological children, then they may get priority over your siblings, because sometimes they may be predeceased, the other person or the person that's passed away, and then you got to look at their children. Okay, so heirs is a very relative term. Talking
to attorney Jasmin Dodson, who's dealt with, has a lot of experience with this estate planning issue. So if you've got a very specific will, Jasmin, if you've taken time and really laid it all out specifically, what are the chances that a judge will actually make any changes to it?
I don't believe that judges have the authority to alter the terms of a will.
Okay.
If a will is set out and it's proven to be a valid will, then that's how things happen.
So even if some kids are left nothing, like he has a brother, Ramon, if he's got nothing, you're saying unless he has some incredibly compelling argument, like what kind of argument would get a judge to rethink a will like that?
It would have to be some kind of undue influence. And normally when I create wills and someone wants to specifically leave someone out or disinherit them, what we tend to do is we tend to give them a nominal amount, say like $1 or something, so that way the court knows that, number one, I've acknowledged that this person is in existence and I didn't leave them out by accident, and number two, I'm intentionally giving them something. So it's not like I just forgot to mention them.
Now, when someone has a condition like Muhammad Ali had for many years, Parkinson's, is there any grounds of argument there in terms of his state of mind during his final years?
Oh, absolutely. I'm sure that he has substantial medical records and had treating physicians, and that's one of those will contest cases where you say there's no way that my father could have drafted this will, and because of his state of incapacity. And then you call all of the doctors and expert witnesses in and offer testimony as to his capacity.
It takes years and years to do all this? Or?
It could take several years.
Yeah, because basically, as far as they know right now, his brother Rahman and Mohammed Jr., they say they've both been left out of the will. But you're saying... let me ask you this, because you said you leave $1. That way the court knows, hey, that was purposeful. But if they're literally not in the will, will they have will they be able to get something out of this?
Possibly. I mean, like I said, if there are facts that support their argument that there was a lack of capacity or undue influence, the judge could look at all those factors and determine that the will is, in fact, not valid. And then his estate may be distributed based on whatever statute that that particular state has regarding the laws of intestate.
Does it help do people ever leave like video wills where they read the will out and specify verbally what's in the will?
In my experience, I tend to find that verbal wills aren't as exact as a handwritten will, because as attorneys, we are drafting basically a contract, so every period and every comma sometimes can count in whether or not somebody's getting something or not.
In all the cases you've dealt with, what percentage would you say were challenged, the wills?
Let's see. Well, none of the wills that I've drafted, so.
So the family members just accept what's there?
Yeah, most of the wills that I've drafted, all of the wills that I've drafted, yes. But there are cases where there are individuals that come up to me and say, this isn't right. However, the other consideration that's important to make is how large is the estate and is it worth fighting for? Right. So if someone is fighting over grandma's antique chair that's worth about $5,000, they don't want to spend $20,000 in litigation expenses trying to fight over it. So sometimes when people want to challenge a will and say, well, I didn't get what I was supposed to get, and then you look at what's exactly in the estate, it may not be worth fighting for.
So have you been the one to tell people that, hey, your father or mother left you $1?
No, I haven't been on that end. But generally speaking, when I'm distributing the estate as the attorney, the executor is the one who makes out the distribution. So the executor will write out the check and give it to the person and say, here's your dollar from the estate. But they also get a copy of the inventory and appraisement to see what exactly was given, where, and why. And then if they want to challenge it, they can challenge it. However, if it's a valid will and the court has accepted it, then there's really no grounds to overturn it unless they can prove that there's an undue influence or a lack of capacity.
Yeah. For someone who feels they don't have enough money to really bother with a will, what do you say to them?
I say take the time and bother with a will. There's been so many instances where people have come to me with wills that they created online, and they want to try to probate these types of wills, and it causes a lot more pain and money than it would take to go to an attorney and get just a simple will drafted
Because
that says
is that a guaranteed family fight? Is that what it is?
No, it's not a guaranteed family fight. It's just there are certain terms and certain things that are missing from these types of online wills because they vary from state to state. So you could be pulling a will form from who knows where, and it might work in one state, but it may not work in your home state. So you try to take that to the probate court in the state where the decedent passed away, and the probate court is saying, well, this is missing all these terms. So, for example, the state of Texas is very strict on witnesses that you have that sign a will and how the language in where the witness is signed, how that has to be. So if you get a will from someplace else and the witness is signed and it's not in compliance with the code, then the court could require these witnesses to come into court and testify. And depending on when the will was drafted, say you've got a will from 84, these people might not still be alive. So then you have to locate them and find them and bring them into court. And like I said, it turns into a big pain. So my advice would be to find a local estate planning attorney, take the time and draft up a will and say who you want your stuff to go, where, and why.
Jasmin Dodson, an attorney herself, deals with estate planning. She's at dodsonlegal.com, dodsonlegal.com. Hey, Jasmin, thanks.
Yeah, thank you for having me.